Welcome to Diagnosing Health Care, a podcast featuring thought-provoking conversations about the latest legal, policy, and regulatory issues in healthcare and life sciences. While these issues may seem like hurdles, we'll also look at the business opportunities and solutions that exist. Diagnosing Healthcare is brought to you by the lawyers at Epstein Becker Green, a leading law firm that has decades of experience serving clients in the healthcare and life sciences industries nationwide.
This week marks the one-year anniversary of the Supreme Court's decision in Dobbs v. Jackson Women's Health Organization and the overturning of the landmark cases Roe v. Wade and Planned Parenthood v. Casey. On this episode of Diagnosing Healthcare, we will reflect on the past year by examining how the Dobbs decision has impacted the legal landscape for patient access to abortion and the provision of abortion-related services, discuss various challenges the healthcare industry has faced in the aftermath of this decision, and explore how industry can manage their compliance efforts moving forward as the legal landscape continues to evolve. Hello and welcome. I'm your host, Jessika Tuazon. I'm a partner in Epstein Becker Green's healthcare and life sciences practice based out of our Los Angeles office. Supreme Court's decision in Dobbs a year ago overturned 50 years of legal precedent, protecting the constitutional right to abortion in the U.S., leaving the question of whether and how to regulate abortion to individual states. While nearly all sectors and industries across America have been impacted in some way by the Dobbs decision, it has overwhelmingly impacted the healthcare industry, resulting in changes that affect stakeholders across industry, from patients to healthcare providers and medical centers, drug manufacturers, distributors and suppliers, pharmacies and pharmacists, and many others whose products or services are used in the development and delivery of abortion and reproductive health care. Over the past year, EBG has been tracking developments related to abortion access and closely monitoring the potential effects of these widely varying laws through our 50-state survey. On today's show, we're going to take a look back at how the legal landscape surrounding abortion care has changed following the Dobbs decision, and how different stakeholders in the healthcare industry have been impacted by and responded to the myriad legal changes and uncertainties that have arisen as a result of this decision. If you like what you hear today, please subscribe to the show. Diagnosing Healthcare is available wherever you get your podcasts. Joining our discussion today is Amy Dow, a partner in the healthcare and life sciences practice based out of EBG's Chicago office. Amy advises companies and investors in the life sciences industry on a broad range of regulatory and transactional matters and co-leads EBG's Dobbs Working Group. It's great to have you on our show today, Amy.
Thanks, Jessica. It's a pleasure to be here.
Also joining us today out of our Chicago office is Erin Sutton. Erin is an associate who helps clients navigate complex regulatory issues with regard to licensure, scope of practice, and telehealth laws. Erin co-leads EBG's team of attorneys maintaining a 50-state survey of abortion laws and has been closely tracking litigation and legislative changes over the past year. Thanks so much for joining, Erin.
Thank you. It's great to be here.
Throughout the past year, Diagnosing Healthcare has covered a number of topics highlighting the wide-ranging impact of the Dobbs decision, from patient access to abortion-inducing drugs, including mifepristone, to the implications on clinical trials and research and evolving developments in legislative and enforcement actions for abortion-related services. As we come upon the one-year anniversary of the Dobbs decision, we think it's important to reflect on the profound impact this case has had on the legal landscape surrounding abortion care, with a focus on how this case has affected the healthcare industry in particular. Before we dive into our discussion today, I'd like to take a brief moment to provide some background on the Dobbs ruling and where the legal landscape currently stands. As our listeners may already know, on June 24, 2022, the U.S. Supreme Court issued its decision in Dobbs v. Jackson Women's Health Organization. At issue in the case of Dobbs was the constitutionality of a Mississippi law banning abortion after 15 weeks of pregnancy. The Dobbs decision explicitly overruled Roe v. Wade and Planned Parenthood v. Casey, which had long upheld women's rights to an abortion under the 14th Amendment. As a result, the Dobbs decision eliminated federal constitutional protections for abortion, putting the decision of whether and how to regulate abortion directly into the hands of individual states. In the immediate aftermath of the decision, the status of abortion rights across the nation were rapidly evolving. Some states had in place trigger ban laws, which would automatically ban abortion in the event Roe and Casey were overturned. Other states sought to revive old laws banning abortion, which had previously been unenforceable under Roe, and others rushed to consider and enact new bans and restrictions on abortion access. As of June 13, 2023, there are 24 states with enforceable laws that restrict abortion more severely than Roe would have permitted, meaning that they ban abortions before the end of the second trimester. Of those 24 states, 8 states have bans that are more severe than Roe would have allowed, but which still allow most abortions in the first trimester. The remaining 16 states have laws that severely restrict abortion, such as banning abortion after 6 weeks of pregnancy. While some of these laws are clear in their scope and application, others are more vague and have not yet been enforced or interpreted by a court of law. As state legislators continue to introduce new bills that impact abortion care, there remains considerable legal uncertainty in the post-Dobbs world. Let's talk about some ways in which this case has specifically impacted the healthcare industry. This past year has certainly been a whirlwind for individuals and companies operating in the healthcare industry. Amy and Erin, now that the initial flurry of state activity has had a little bit of time to settle, what are your thoughts on the current legal landscape around abortion care 1 year later? And is there as much uncertainty around the laws governing abortion care today as there was 12 months ago?
Thanks, Jessica. Yes, it has been a whirlwind for our clients and for our team of attorneys advising them. Let's first consider that initial flurry of activity. Even before the Supreme Court announced its decision in June, we recognized that if the decision was consistent with the draft that was leaked in May in its overturning of Roe and Casey, it would have an enormous impact on our clients. Shortly after that draft was leaked, we kicked off our efforts to begin cataloging and analyzing the trigger bans and other laws that were on the books, so we would be prepared to understand and advise our clients on the state of the law once the decision was announced. We immediately recognized the enormity of the challenges our clients would face in attempting to comply with the overlapping and often inconsistent laws on the books in the states we expected to attempt to ban or severely restrict abortion if Roe was overturned. Many of the laws on the books for which enforcement had been enjoined as a result of the protections offered by Roe v. Wade had been enacted in the 1800s, with additional restrictions layered on in various forms over the ensuing decades. Sure, there were the obvious laws governing abortion procedures themselves, who could perform them, when and in what facilities, what exceptions applied for life or health of the pregnant person, and in some cases, situations such as ectopic pregnancies or treatments of miscarriage. But many other laws also impact the ability of providers to provide abortions and other reproductive health care services. For example, how a state defines when life begins determines whether abortion, miscarriage treatment, or even some procedures common in fertility treatments could be prosecuted as a homicide. Just getting our arms around all of those categories of abortion restrictions that needed to be considered, from restrictions governing the practice of medicine, the operation of healthcare facilities, to privacy laws, the criminal code, and state constitutions, was an enormous challenge. Following the release of the Dobbs decision, state legislatures immediately began proposing and passing new bans in rapid succession, often without addressing how those new laws impacted and should be interpreted based on the existing laws on the books. Beyond needing to analyze the evolving laws, companies had to consider how prosecutors in various jurisdictions would enforce those laws and what protections might be available under federal laws like EMTALA or the Constitution's Dormant Commerce Clause and right to interstate travel. It created an incredibly challenging legal landscape for many providers to navigate.
As Amy just mentioned, we can summarize the last year as an attempt to untangle the web of state laws in states that restrict abortions and to fill in any gaps both in the states that have those restrictions, but also in the states that have sought to provide protections for access to abortion. A year later, I don't think we're as far along in defining which laws are valid and enforceable and how they'll be enforced as we might have hoped. Kentucky's progress over the past year provides a representative example of this tangle of laws and flurry of activity. In Kentucky, after Dobbs, you had 3 overlapping bans: a total prohibition, a 6-week ban, and a 15-week ban. These were in addition to restrictions on the method of abortion, restrictions related to reporting, additional restrictions on drugs prescribed for medication abortion, and restrictions on obtaining informed consent, just to name a few. In order to sort out which of these many laws would be enforced or which were valid in light of textual conflicts, providers sued in state court to challenge the constitutionality of the total prohibition on abortion and the 6-week ban under Kentucky's constitution. Meanwhile, an ongoing federal lawsuit filed by providers who performed abortion in 2022 when the state passed a bill regulating medication abortion, reporting of abortion, and the 15-week abortion ban took on new significance after Dobbs. Finally, a separate state court case challenged a law restricting a common surgical abortion procedure. At many points during the last year in Kentucky, as you can imagine, not only did you have overlapping laws, but you had overlapping injunctions in both state and federal court. It took the majority of this year to resolve the litigation. In February, the Kentucky Supreme Court ruled in a 150-page decision full of concurrences and dissents to allow both the total ban and the 6-week ban to be enforced, while remanding the case to district court. More recently, in May, the federal case was ultimately dismissed, allowing the reporting restrictions and the restrictions on medication use for abortion to go into effect. As Kentucky exemplified, we've watched as state Supreme Courts have become a new important battleground to define or reject protections under state constitutions. States like South Carolina, Idaho, North Dakota, Montana, and Oklahoma have all delivered opinions on their state constitutions and state abortion laws, with South Carolina, North Dakota, Montana, and Oklahoma delivering full or at least some protection from state restrictions. Later this month, Wisconsin's Supreme Court will hear arguments in its closely watched lawsuit challenging the state's pre-Roe abortion law, and similar contests before Ohio's Supreme Court and Florida's Supreme Court will define access for millions. In the meantime, Kentucky was also one of several states in the past year that had abortion as the topic of a ballot initiative in the state's general election. Kentucky voters last November rejected a ballot measure that would have further restricted abortion under the state's constitution. Michigan, Vermont, and California used ballot measures to expand protections, while Montana and Kansas, similar to Kentucky, tried to restrict access and had those initiatives rejected in favor of maintaining access. New York and Maryland have already certified constitutional protections on their 2024 ballots, with Ohio and Missouri fighting to do the same. Again, as states like Kentucky have demonstrated, we expect the laws and the challenges to their enforceability to continue into the foreseeable future.
Thank you both. This is really shedding light on how complicated and challenging it's been for everyone as we all try to make sense of the legal landscape. While we don't have enough time in today's podcast to cover all of the different challenges that have impacted every corner of the healthcare sector, could you describe some of the biggest challenges your clients in the healthcare industry have had to face? And how have those challenges changed your clients' approach to providing services or products that are used in abortion or reproductive care?
There is no question that healthcare professionals and the healthcare entities that employ and facilitate their care in states with restrictions have carried some of the heaviest burdens this past year. Emergency medical departments still are uncertain on how to legally comply with state restrictions and mandates. A recent study found that when callers posing as patients in need of emergency abortion care phoned hospital emergency departments, not one hospital in the entire state of Oklahoma could articulate a clear policy or tell the patient whether they would be able to receive care at the facility. There has been reporting out of Tennessee documenting pregnant people denied abortion care, with one woman who was unable to access an abortion forced to carry a high-risk ectopic pregnancy because the state criminalized all abortions, even for those performed to save the patient's life. A physician would only be able to raise an affirmative defense, and with the state's severe criminal penalties, which could amount to life in prison, no provider was willing to risk it. Tennessee recently passed a new law allowing for abortion in case of ectopic pregnancy and removed the affirmative defense only scheme, but it is not only as clear or protected as emergency care in Oklahoma was at the time of that report. It is challenging when we have state legislatures seeking to define terms like medical emergency or medical necessity or other exceptions who lack medical training to understand how these terms are commonly used in medical practice. Compliance departments and ethics committees can be stuck between interpreting the legislature's unyielding definitions and fielding their providers' nuanced, patient-specific questions. Facing these uncertainties and ethical difficulties, reporting over the past year has covered physicians leading states with restrictions. With labor and delivery department closures in hospitals in states like Idaho, which were already lacking in adequate OB/GYN care. The pressure to enforce protections has increased, with several women in Texas suing the state for the harm they endured while waiting on emergency care during near-fatal pregnancy complications, and reporting has covered similar stories in Ohio and Missouri. So, hospitals and health systems are faced with few good options for retaining and protecting professionals and securing their operations. On the one hand, their providers could risk draconian penalties that range from fines and life imprisonment for providing emergency abortion care. And on the other hand, the facility could be liable under federal law, EMTALA, for not providing emergency care to patients who present to their emergency rooms. All of this exists on top of the record levels of burnout in physicians, nurses, and other frontline healthcare workers from the COVID-19 pandemic. Hospitals and employers may continue to struggle to retain an adequate workforce to serve their patient populations. It can also be challenging for health systems to craft comprehensive and cohesive policies while operating across multiple states. For example, with the recent uncertainty around access to the medication mifepristone due to lawsuits in Texas and Washington state, healthcare systems that operated in states like Indiana that would have been impacted by a removal of mifepristone from the marketplace, as well as states like Illinois, whose attorneys general had secured an injunction from the same ruling, would have had to develop a two-tiered ordering system for medications or multiple policies to address the reality that they would be prohibited from acquiring the medication in one state, but would still have access in another. Though, meanwhile, many states have been acting aggressively to protect access to abortion, and the providers and facilities who perform them, such as California, New York, Illinois, Minnesota, Nevada, and Hawaii, to name several, that have passed laws to protect licensed professionals from adverse action by medical boards and out-of-state investigations. All of this may further drive technologies like telehealth and medication abortion as the solution to fill in gaps in care.
Thanks, Erin. I agree with your perspectives on the significant challenges impacting healthcare provider entities. We've seen other organizations facing similar struggles to keep up with the evolving legal landscape. Entities involved in the manufacture, distribution, and dispensing of prescription drugs, including providers making mifepristone and other abortion-inducing drugs available via telemedicine or by mail, have been particularly impacted by the ongoing mifepristone litigation making its way through the federal courts this year. We discussed that litigation in depth in a recent podcast, so I won't repeat those details here, but in essence, a series of recent decisions by the Federal District Court for the Northern District of Texas, the Fifth Circuit Court of Appeals, and the U.S. Supreme Court in the case Alliance for Hippocratic Medicine v. FDA, and a conflicting decision out of the U.S. District Court for the Eastern District of Washington in a separate overlapping case, left entities in the supply chain for these drugs struggling enormously to plan to comply with court decisions that might have alternatively left them in a position of being prohibited from dispensing mifepristone if its FDA approval was halted as a result of the Texas District Court decision, while also being impacted by the Washington District Court decision that restricts FDA from taking any action to restrict access to mifepristone in Washington, D.C., the state of Washington, and in 16 other states that joined the Washington case. Imagine the challenges for entities operating on a national level and subject to national contracts with national computer systems to assess their legal risks and rapidly shift their operations in an effort to comply with the law in each state in which they operate. These organizations will continue to grapple with these challenges as the cases continue to make their way through the courts this year.
Thanks, Amy and Erin. This has been a great discussion about the difficulties and challenges we've seen in 1 year of a post-Dobbs environment. As we enter into year 2, are there different challenges or other hurdles that you think the healthcare industry should be prepared to face in the months to come?
I think it's safe to say that we will continue to deal with the fallout from the Dobbs decision for the next year, if not many more to come. Just as Roe and Casey did not settle abortion law, I think Dobbs has not offered the clarity that the Supreme Court perhaps envisioned. On the legislative front, I think we'll continue to see some state legislatures looking for new and creative ways to target access to medications used for abortion and telehealth, which can be harder to investigate than traditional brick-and-mortar healthcare operations. And we'll probably see just as many seeking to find new ways to protect access to care. We also have to consider states like Nebraska, North Carolina, Kansas, Pennsylvania, Arizona, and others, where the state status quo may last only until the next election. Arizona and North Carolina provide good examples here. Leading into Dobbs, Arizona was pursuing one of the more aggressive anti-abortion fetal personhood schemes with a more conservative governor and attorney general. Now, after that election, Arizona's new attorney general has actually signed onto amicus briefs in support of abortion access in some of the mifepristone litigation. North Carolina also recently passed a veto-proof abortion ban on abortion after 12 weeks gestation, but with some severe limitations on advertising abortion and even prohibiting physicians from advising patients on the option of abortion after 12 weeks. The legislation only passed because a Democratic state representative announced that she had switched to a Republican at the last minute, allowing it to be enacted by the narrowest of margins. I think there are several interesting federal constitutional questions that haven't been raised yet. We've seen questions of preemption in the pair of cases pitting the federal EMTALA against state laws in Texas and Idaho. But I think there may be Commerce Clause challenges or right to travel cases looming, depending on how far states seek to extend their laws. Of course, we're all standing ready to respond from the pending decision in the mifepristone case, Alliance for Hippocratic Medicine versus the FDA. But I'm also curious to see whether the Fifth Circuit or the Supreme Court will address the 100-plus-year-old Comstock Act and interpret for the first time its impact on mailing medications or equipment used for abortion. If not in the mifepristone case, there are lawsuits out of states like Nevada that may be seeking to tee up this issue for review.
Thanks, Erin. As I look ahead to the next year and the years to come, I expect organizations to continue to evolve their practices and identify new areas of risk they'll need to address as we continue to observe changes in relevant laws and learn from trends in enforcement. Companies other than organizations providing abortion services that may have been sitting on the sidelines in the year following the Dobbs decision and waiting to assess how the decision will impact their operations may be forced to act as the level of risk to their businesses becomes more apparent over time. On the one hand, providers of fertility services that might have initially modified certain treatment practices, such as selective reduction of multiple implanted embryos, or their decisions relating to the storage and disposition of embryos, may ultimately find that the states are not bringing enforcement actions against fertility providers based on the broad definitions of fetal personhood that could be interpreted to restrict these procedures. Over time, in the absence of enforcement, they may become more comfortable with their legal risks and begin to resume some practices considered to provide safer, more effective patient care. Other entities, such as drug manufacturers conducting clinical trials, particularly those on investigational drugs that may expose a developing fetus to abnormalities, may find that they are subject to substantial liabilities when they conduct those studies in states in which a study participant who becomes pregnant does not have access to an abortion. If those pregnancies are carried to term, a manufacturer may need to bear the cost of ongoing medical care for a child that suffers ongoing illness as a result of exposure to an investigational drug. Facing those realities, manufacturers may shift their research to states in which abortion is a more readily accessible option for participants who become pregnant. I would be remiss if I didn't point out the potentially far-reaching impact of those decisions on the quality of the broader range of healthcare services available in states in which abortions are not accessible. Patients in those states may have more limited access to cutting-edge treatments when manufacturers take their research elsewhere and top providers interested in participating in research and the development of new therapies follow. In the year since the Dobbs decision, as Erin mentioned, we've already begun to see those trends emerge, facing criminal penalties in states with abortion restrictions and the inability to obtain comprehensive training in those states. A survey of third and fourth year medical students conducted by the Association of American Medical Colleges last fall revealed that a majority of medical students were unlikely or very unlikely to apply to any residency program in a state with significant abortion restrictions. Nearly 77% reported that access to abortion care would influence where they applied for their residency. My concern is that over time, we may observe significant disparities in medical care between states that severely restrict access to abortion and those that don't. Provider organizations in those states will certainly struggle to overcome these challenges in recruiting and retaining highly qualified healthcare providers as a result.
Great. Thank you, Amy and Erin. This discussion today has been so informative. We've now talked about how abortion laws have changed over the past year and the types of challenges the healthcare industry has had to face following the Dobbs ruling. We've also talked about future challenges that likely lie ahead for the healthcare industry. To close out our discussion on Dobbs today, what are some of the practical tips that companies in the healthcare industry can implement to help manage their legal compliance posture moving forward?
Thanks, Jessica. I think we're in a new reality where those operating in the healthcare industry can no longer rely upon a uniform federal standard for activities that might impact reproductive health. Providers, patients, payers, employers, and distributors, et cetera, will all have to learn to navigate a 50-state system of changing laws and litigation impacting those laws. For example, while there are new protections under HIPAA and in some states laws for reproductive health data, there are just as many states that could be preparing to subpoena those data in an investigation under the state's criminal law. But I think, to end on a hopeful note, it is possible to navigate these challenges. We have been helping clients track legislative changes across the 50 states and following national and local litigation that impacts all aspects of reproductive health care. Attorneys here have actually been on the phone with hospital clients late at night, minutes after a state allowed its long dormant abortion ban to take effect, helping to figure out compliance. We've helped benefit plans and employers evaluate options for reproductive health coverage and helped IVF providers understand how they can store and dispose of embryos, as well as assess whether they are able to operate as usual in a post-Dobbs world. While it's still too early to provide any certainty, there's a lot we can do to navigate what we do know.
Thank you so much, Amy and Erin, for taking the time to speak with me today about the far-reaching impact the Dobbs decision has had on the healthcare industry and practical compliance measures industry may want to consider as it continues to navigate this evolving legal landscape.
Thanks, Jessica, for hosting this interesting and thought-provoking discussion. It's been great to be here with you today.
Yes, thank you so much. It's been a great conversation.
And thank you to all of our listeners. I'm your host, Jessika Tuazon. If you are interested in learning more about Epstein Becker and Green's impact from Roe to Dobbs 50-state survey, or would like to listen to the other podcasts in our Post-Dobbs series, please visit our website. And if you like what you've heard today, please don't forget to subscribe. Diagnosing Health Care is available wherever you get your podcasts.
Thank you for listening to Diagnosing Health Care. For show notes on today's episode, additional episodes, and more insights on trending issues in healthcare and life sciences, please visit diagnosinghealthcare.com and be sure to subscribe on your preferred platform. This podcast is presented by Epstein Becker Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of legal services to be performed is greater than the quality of legal services performed by other lawyers.